Hello and welcome to LawPutra YouTube channel. My name is Ananya and today we will be discussing about the mode of execution which has been provided under Order 21 of the Civil Procedure Code. Now I know that Order 21 itself is a mammoth of an order and everybody is scared of it, but I will try my best to make it as simple as possible for you. So before I start with talking about the modes of execution, it is first important to have a brief overview of the Order 21. So first it is to be realized which court will execute a decree. The same has been provided under section 38 of the code, and it states that a court which passes the decree can execute the decree. Also, a court to which the decree has been sent for execution can execute the same. Another thing is that the application has to be made to the court by the decree holder for the decree to be executed. Then there are certain questions that might arise while executing a decree, and the same questions will also be determined by the executing court. Now there are several processes such as the process of stay of execution, cross decrees, redistribution of assets. Then comes the modes of execution, then arrest and detention, attachment, sale or delivery of the property with regards execution. So this is a brief overview of the Order 21 which you will need to understand in order for a better understanding of the modes of execution. Now we will begin with the main topic of our discussion today, that is the mode of execution of a decree. There are several steps that a decree holder has to follow or comply with in order for his decree to be executed by the court. The first step that he has to keep in mind or has to follow is that the decree holder has to file an application for executing the decree to the court that has to execute the decree. So you can say that it is the duty of the decree holder to have his decree executed, and there is a limitation period attached to it as well, and he has to apply to the court for the execution in that certain amount of time. When we talk about the execution of a decree, we cannot forget section 51 of the Civil Procedure Code. It is section 51 of the code that enumerates various methods for execution of a decree. And Order 21 is also there. It is much more comprehensive and it deals with particular instances or particular types of decrees and how they will be executed by the court. But it is section 51 which lays the foundation for the same. Section 51 is titled Powers of Court to Enforce Execution. It provides with 5 different kinds or 5 modes for execution of a decree. The first is by delivery of property from the judgment debtor to the decree holder. The second is by attachment and sale or sale without attachment. The third mode is by arrest and detention as per the provisions of section 58 of the code. The fourth is by appointing a receiver, that is being done under Order 40 of the code. And the last is any other manner as the relief might require. So it also gives a little bit of discretion to the court. So you saw that there are 5 modes of execution available to the decree holder as a remedy. But a point of contention और एक problem जो हमेशा चलती रही है is that क्या इन सारे modes में से can a decree holder pick and choose कि वो किस mode से अपनी decree को execute कराना चाहता है? So the same has been decided over various case laws that we will be discussing now. In the case of Mahadev Prasad Singh versus Ram Lochan 1980, it was provided or it was given that as a general rule, a decree holder has an option to choose a particular mode for executing and enforcing a decree passed by a competent court in his favor. But this particular option to choose from the various modes of execution is subject to some conditions as has been provided under this code, or they will depend on the discretion of the court. So with that we can conclude that yes, the decree holder does have a right to choose from various modes of execution. However, that right is not absolute and restricted with regards some conditions or limitations as have been imposed either by the code itself or the court. Now, another thing that caused controversy in this regard was whether there can be simultaneous execution. So, it means that एक ही डिक्री को क्या एक से ज़्यादा मोड्स के थ्रू एग्जीक्यूट कराया जा सकता है? So, that was addressed by the courts in a number of cases, and we will be discussing that now. So, in the case of Shyam Singh versus Collector for District of Hamirpur, it was held that for recovery of certain debts, simultaneous proceedings for attachment and sale of movable as well as immovable property can be taken. The same was held in a case before that in PR Sugar Works Limited versus Land Reforms Commissioner in the year 1969. It was held by the court, the Supreme Court itself, that Section 51 gives an option to the creditor to enforce a decree against the person or the property of the judgment debtor, and nowhere has it been laid down that the execution against the person of the debtor shall not be allowed until and unless the remedy by the decree holder against the property has been exhausted. So now we have understood general provisions with regards decree, which is section 51. We have also seen whether the decree holder has a choice with regards the manner of execution of a decree, and we have also seen with the help of case laws that a decree can be executed simultaneously. One or more modes of execution can be used for the execution of one decree. Now we will move on to Order 21, which provides with modes of executing different types of decrees. So Rule 30 to Rule 36 specifically deal with different kinds of decrees and how their execution will be taking place. So Order 21 Rule 30 talks about decree for payment of money. Now it gives the following modes in which a decree for payment of money can be enforced. So it states that a decree for payment of money can be executed by the detention in civil prison of the judgment debtor, by attachment and sale of his property, or both. So simultaneous, as we understood before. Now coming to Order 21 Rule 31, which talks about decree for specific movable property, not just any property, specific movable property. So the execution of the decree will be done by seizure and delivery, by detention of the judgment debtor, by attachment and sale of his property, or by attachment and detention both. In this, you just have to remember that this property has to be specific movable property, and it would not include money, because money we have already dealt with under Rule 30, right? And so it would not include money. It is specific movable property. Another thing, that the property must be in the possession of the judgment debtor. So if the property is in the possession of a third person, Rule 31 will not apply to that property. We spoke about Rule 31 of Order 21, which talks about specific movable property. Now we will come to Rule 35 of Order 21, which talks about decree for movable property. I will come back to the remaining rules of the Order 21 later on, so that we don't break the flow of movable and immovable property. So we will first discuss about movable property and immovable property, then we will be discussing about that. I have already discussed movable property. Now let's talk about how the decree is executed for immovable property. So the decree for immovable property, there are three types of things that you have to remember. We will simultaneously be understanding Rule 35 and 36. So first is property that is in possession of a judgment debtor or any person that is bound by a decree. So it can be executed by removing the judgment debtor or person bound by the decree and delivering the possession to the decree holder. Now another thing that has been given under Rule 36. I'm talking about Rule 36 first also, because it is somewhat similar in nature, so it is better for understanding. Okay. So Rule 36 says that property is in possession of a tenant or a person entitled to occupy and not bound by decree. How will a decree for immovable property be executed then? So, Rule 36 of the Order 21 provides that delivery of the property will be made by affixing copy of the warrant at some conspicuous place on the property. Conspicuous as in place जहाँ पे आते जाते आप देख सको, उसको ऑर्डर को पढ़ सको. और उसके अलावा एक और चीज, that is by proclaiming the occupant. By proclaiming the occupant by beat of drum or other customary manner. चिल्लाकर, है ना, लाउड स्पीकर पर आपको बेसिकली टेनेंट को और ऑक्यूपेंट जो भी और है, टेनेंट के अलावा लेसी हो सकता है, कोई भी हो सकता है, यू हैव टू इन्फॉर्म देम कि नाउ दिस प्रॉपर्टी हैज बीन डिक्रीड टू सम अदर पर्सन एंड सो यू हैव टू डिलीवर द पोजेशन. बस वही करना है. सो रूल 35 वी अंडरस्टूड, जब वो पोजेशन में है जजमेंट डेटर के एंड द जजमेंट डेटर और एनी पर्सन दैट इज बाउंड बाय द डिक्री, वो समझ लिया. उसके बाद में जब वो रूल 36 में जब वो पोजेशन में है टेनेंट के या ऐसे किसी बंदे के, दैट इज नॉट बाउंड बाय द डिक्री. नाउ अनदर थिंग विच इज बीन गिवन अंडर रूल 35 अगेन, इट इज जब वो उस बंदे के पोजेशन में है दैट इज बाउंड बाय द डिक्री बट डज नॉट अफोर्ड फ्री एक्सेस. अ पर्सन इज बाउंड बाय द डिक्री बट डज नॉट अफोर्ड फ्री एक्सेस वुड मीन कि वो आपको पोजेशन नहीं दे रहा है डिस्पाइट द फैक्ट द कोर्ट हैज डिक्री उसके फेवर में आ गई है, डिक्री होल्डर के पास डिक्री है, जजमेंट डेटर फिर भी पोजेशन नहीं दे रहा है. उस केस में क्या किया जाएगा? सो द कोर्ट में आफ्टर गिविंग रीजनेबल वार्निंग एंड फैसिलिटी टू एनी वुमन जो कि पब्लिक में अपीयर नहीं करती है एज पर द कस्टम्स ऑफ द कंट्री, जैसे कि पर्दानशी लेडीज, तो उनको दे विल गिव रीजनेबल अपॉर्चुनिटी टू विदड्रॉ फ्रॉम द फैसिलिटी एंड आफ्टर दैट दे विल ब्रेक ओपन इनटू द बिल्डिंग एंड पुट द डिक्री होल्डर इन पोजेशन. यानी कि सीपीसी में भी जोर जबरदस्ती कर सकते हैं. एंड ऑल्सो वन वेरी इंपॉर्टेंट थिंग दैट हैज टू बी केप्ट इन माइंड इज दैट while executing the decree, the executing court can also be given mean profits. Mean profits, briefly I'll tell you, are those profits that a person who has been in wrongful possession of a property has earned from that property, which the decree holder, had he been in that possession, could have or would have earned, and he could not earn because the possession was taken from him. So the executing court will also award mean profits, can also award. It is the discretion of the executing court. And these are three things about Rule 35 and Rule 36 of Order 21 that have to be kept in mind. There is a case also of Samshuddin versus Abbas Ali, which held that Order 21 Rule 35 is khas or actual possession, while Rule 36 is former or symbolic possession. क्यों? क्योंकि Rule 36 में हम क्या कर रहे हैं? We are just putting a warning on a conspicuous place, while in Rule 35 हम क्या कर रहे हैं? हम actually we are breaking open and we are making sure that the decree holder is in possession of the property. He comes in the possession of the property. So that is why Rule 36 will be said to be formal or symbolic possession. On the other hand, Rule 35 is khas or actual possession. So until now, we have understood Rule 30 that talks about decree for payment of money, Rule 31 that talks about decree for specific movable property, Rule 35 and Rule 36 that deal with immovable property, decree for immovable property. Now we will be looking at Rule 32, which deals with decree for specific performance of restitution of conjugal rights or for an injunction. Now, simply I'll just tell you what is restitution of conjugal rights. It is when कोई भी husband या wife दोनों में से कोई भी घर छोड़कर चला जाता है without any reasonable cause, तो the court orders, जो भी घर छोड़कर गया उसको, the court orders कि come back to your household and live together. So that is restitution of conjugal rights. Okay. So इसमें सिर्फ एक ही Rule 32 provides with only one mode of execution for restitution of conjugal rights, that is by attachment. And it is Rule 33 that is vast and expensive in this regard, and it gives the discretion to the court in executing decrees of conjugal rights. So rule 33 states that notwithstanding anything in rule 32, यानी कि it is an overpowering section, and it states that court may either at the time of passing decree against the husband, usually against the husband ही decree जो है with regards rule 33 will be made, or at any time afterwards, यानी कि at the time of passing also, और pass करने के बाद में, लेकिन afterwards also say that the decree be executed as per the manner in rule 33. Now what is the manner? The manner is, in the event of decree not being obeyed within the fixed period of time for obeying, the judgment debtor shall make periodical payments to the decree holder as may be just. The court will say you have to make periodical payments as in 1 महीने में, 2 महीने में, 6 महीने में, जब भी जितना भी कोर्ट बोलेगा. as may be just means की discretion of court. So the court may from time to time vary or modify the order of periodical payments. Now the court is having another power, that is to vary or modify the order of periodical payments. Another thing the court can do is that the money ordered to be paid under this rule may be recovered as decree for payment of money would be recovered. Now back to rule 30. So there is this link that you have to understand. So वहां पर क्या दे रखा था कि by detention in civil prison, by attachment and sale of his property, or by both. So ये दो तरीकों से वो अटैचमेंट से और डिटेंशन से डिक्री को रेस्ट्रिक्शन ऑफ कंजुगल राइट्स की अंडर रूल 33 भी कराया जा सकता है, बट स्पेसिफिकली रूल 33 में डिस्क्रिशन से कोर्ट के पास होने चाहिए. एंड द नॉर्मल प्रोसीजर फॉर रेस्ट्रिक्शन ऑफ कंजुगल राइट्स वुड बी रूल 32. नाउ कमिंग टू रूल 32 टू, इसमें जो दूसरी चीज है वो ये है रूल 32 में, दैट टॉक्स अबाउट स्पेसिफिक परफॉर्मेंस ऑफ अ कॉन्ट्रैक्ट और फॉर एन इंजंक्शन. नाउ द कॉन्ट्रैक्ट, स्पेसिफिक परफॉर्मेंस ऑफ कॉन्ट्रैक्ट और इंजंक्शन की जो डिक्री होगी दैट कैन बी इन्फोर्स्ड बाय डिटेंशन, अटैचमेंट और बोथ. Now coming to rule 34 of order 21. So rule 34 talks about decree for execution of document or endorsement of negotiable instrument. Negotiable instrument, it is bill of exchange, checks, promissory notes, etc. etc. Those are all negotiable instruments. So उनकी डिक्री जो है उसको कैसे एग्जीक्यूट कराया जाएगा. Now बाकी सारे प्रोसेसेस वर अ लिटिल सिंपल, यू कैन से, उनके लिए एक ही मोड रिपीट हो रहा था, बट दिस इज ऑल टुगेदर अ वेरी न्यू वे ऑफ इन्फोर्सिंग अ डिक्री एंड इट इज वेरी इंटरेस्टिंग ऑल्सो. सो हाउ इट विल बी इन्फोर्स्ड, एग्जीक्यूटेड इज द फर्स्ट थिंग, द जजमेंट डेटर हैज नेग्लेक्टेड और ही हैज रिफ्यूज टू ओबे द डिक्री. सो व्हाट विल द डिक्री होल्डर डू नाउ? द डिक्री होल्डर विल प्रिपेयर अ ड्राफ्ट ऑफ डॉक्यूमेंट और एंडोर्समेंट इन अकॉर्डेंस विद द टर्म्स ऑफ द डिक्री, and then the decree holder will deliver the same draft to the court. Now the court will cause the draft to be served upon the judgment debtor with a notice requiring his objections. तो ड्राफ्ट बनाया सबसे पहले डिक्री होल्डर ने, उसके बाद में कोर्ट को भेजा. अब कोर्ट क्या करेगा? कोर्ट वो ड्राफ्ट भेजेगा जजमेंट डेटर को और उससे पूछेगा कि क्या आपको कोई ऑब्जेक्शंस हैं. नाउ अगर जजमेंट डेटर ऑब्जेक्ट करता है, सो ही हैज टू ऑब्जेक्ट और गिव ऑब्जेक्शंस इन राइटिंग. नाउ द कोर्ट विल आइदर अप्रूव द ऑब्जेक्शंस और if they have approved the objections, so they will ask the decree holder to alter the decree or they will approve the draft. So the court will now order approving or altering the draft as it thinks fit. जो भी होगा court will order now. Now decree holder after making those alterations जो कोर्ट ने उसको बोले हैं करने के लिए in his draft, he will make those alterations. और अगर जरूरी है, if it is required by law, तो स्टैम्प पेपर पर वो उसको कोर्ट को भेज देगा. उसके बाद में कोर्ट क्या करेगा? द जज और द कोर्ट ऑफिसर विल एग्जीक्यूट द डॉक्यूमेंट. वन मोर वेरी इंटरेस्टिंग थिंग that rule 34 talks about is registration. अब हम डिक्री को एग्जीक्यूट करा रहे हैं तो देयर कैन बी टाइम्स उसको डिक्री को एग्जीक्यूट कराते हुए नेगोशिएबल इंस्ट्रूमेंट्स ऐसे भी तो होते हैं जिनको रजिस्टर कराना पड़ता है. सो व्हाट इफ द रजिस्ट्रेशन ऑफ डॉक्यूमेंट इज रिक्वायर्ड? सो द कोर्ट इटसेल्फ विल कॉज द डॉक्यूमेंट टू बी रजिस्टर्ड. अब registration is not required, however the decree holder desires it to be registered. तब court क्या करेगा? Then court will make any order that it thinks fit. And court will also make an order with regards the expenses of registration. कि expenses उसके decree holder pay करेगा या judgment debtor pay करेगा. So that was all with regards mode of execution of decree, wherein we understood section 51 and we also understood order 21, rule 30 to rule 36, which specifically deal with different kinds of decrees and how they will be executed. I really hope that I was able to make you understand the concept easily and that you had enjoyed watching the video. And please be connected to LawPutra, and I hope to see you again. Thank you.